Yeah, so my name's Andrew Nixon. I'm a partner in the sports group here at Sheridans. The sports group at Sheridans obviously has a very well-established sports media rights practice headed up by Morris Bentata and Paul O'Dowd. My specific practice is in the regulatory side of sport, the rules and regulations and dispute resolution. I think, there's not many lawyers who would put their hands on heart and say that a process such as arbitration is inexpensive, because that would be untrue. It can be very expensive, and at times just as expensive and indeed lengthy as litigation. But from a sporting perspective, any form of ADR, whether it be mediation, internal disciplinaries, any form of arbitral process, does tend to be quicker and more cost effective and also more flexible, and that is incredibly important from a sporting perspective and a sporting regulatory perspective. I mean, if you take as an example the London Welsh arbitration from last summer, that was a case which needed to be resolved before the fixture lists were published for the coming season. It was also a matter which had relatively complicated arguments on EU and UK competition law, and had that matter proceeded through the courts, it would have inevitably have taken many months, if not potentially years, to reach final determination. But through the sports arbitral process, the sport in question was able to reach a fair and conclusive determination, utilising a tribunal with experts in both the sport and the law, and a decision which was in the interest of the sport. Arbitration, I've touched upon it, is obviously very important within the context of sport, because it generally speaking has a degree of finality, and we've seen very recently, just last week with the ECB and Canaria case, that internal sports disciplinary matters can be arbitrable, provided the makeup of the tribunal is sufficiently judicial and the process is sufficiently judicial. But as well as arbitration, mediation is becoming increasingly popular, increasingly important within the context of sport, quite obviously, because it provides the platform for disputes to be resolved privately and cost effectively, and also speedily. And a lot of governing bodies are now writing in mediation clauses into their disciplinary rules. And it's not uncommon also for sports, in particular governing bodies, to seek expert opinion from experts in the sport and indeed the law in order to resolve internal disputes, potentially between an athlete and a governing body. It's incredibly important. There's no question about that. I mean, we've touched upon some of the issues. Sport, like a lot of industry sectors, but not many industry sectors have the profile of sport. It doesn't want to have its, for want of a better phrase, dirty linen aired in a public forum. And ADR, whether it be a standard form internal process, a formal arbitral process, or simply mediation, allows sport to resolve its internal matters in just that way, internally, and without the public eye peering in. I think it's very difficult to appeal an arbitral award. You can appeal on a point of law, provided the parties haven't agreed to dispense with that entitlement between themselves, which is quite common. You can also appeal under the Arbitration Act 1996 from a domestic perspective if there has been significant irregularity on the part of the arbitrator, and obviously the definition of serious irregularity is contained in the Arbitration Act. One connected point, though, relates to, and I sort of touched upon it earlier when I talked about arbitration being 9 times or 9.5 times out of 10 the final or the end of the road, because it can, in certain circumstances, lack finality, particularly when another regulating body has jurisdiction or may have jurisdiction. That's particularly an issue from a sporting context, particularly when competition law arguments are raised, for example. If you look at the AEK Athens Slavia Prague case, which came before the CAS, I think over 10 years ago now, CAS, it was a common interest case, and CAS ruled that there was no breach of then Articles 81 and 82 of the EC Treaty, but the Competition Commission considered itself entirely unconstrained by the CAS ruling. Now, the matter didn't proceed from that point onwards, but the Competition Commission made it clear that it was unconstrained. So in those circumstances, it is arguable that an arbitral award may lack a degree of finality. Well, again, I mean, I go back to that point earlier in that arbitration isn't necessarily an inexpensive process, and indeed it can be quite the opposite. I do think that the CAS and ICAS do a pretty good job in trying to keep processes and procedures as compact as possible, and therefore costs as compact and indeed as low as possible. Ultimately, however, when it comes to serious sporting issues and issues that need expert determination, there's obviously few better arbitral bodies and tribunals than the CAS to make those determinations. I do think from a domestic perspective, Sports Resolutions deserves a significant degree of commendation for the work that they've done within the context of sports disputes in the UK. They have an extraordinary record of sports dispute resolution, an extraordinary record of doing so, with real cost effectiveness.